If you want to send someone to prison, the justice system demands one non-negotiable step. Your evidence and your witnesses must be cross-examined. Courts demand the ability to test a story, which is why they throw out hearsay. Hearsay is second-hand, unverified information. If a witness didn't see an event themselves, they can't be questioned on the details, rendering their story legally useless. But this creates a massive problem in the ultimate crime, murder. What happens when the only person who saw the attack is the victim themselves, and they are killed? Without the victim's testimony, a killer walks free, but a court cannot cross-examine a ghost. Justice requires questioning, but the only person with the answers is dead. The Indian Evidence Act contains a massive loophole to solve this exact problem. It's found in Section 32, Clause 1, commonly known as the Dying Declaration. Under this specific law, the strict rule against hearsay is completely suspended. A victim's final words about how they died, completely uncross-examined, can serve as the sole reason a person is sent to prison. The law steps in where biology fails, allowing the final, fleeting breaths of a victim to speak directly to the judge. Before we unpack the fascinating psychology behind this law, make sure to like this video, share it with your fellow true crime and law enthusiasts, and hit subscribe. So, why does a famously strict legal structure abandon its most rigid rule? Why does the justice system trust a witness it absolutely cannot question? The answer rests on two pillars. The first is pure necessity. If courts simply ignored a dying victim's final statements, anyone who attacks an isolated, solitary victim would automatically get away with it. The second pillar is a psychological assumption rooted in an ancient Latin maxim, nemo moritoris praesimator mentiri. Translated, this means no person will die with a lie on their lips. The thinking is that when someone faces their imminent end, the motive to fabricate a story vanishes. The law views the physical approach of death as the ultimate psychological filter, stripping away any worldly reason to deceive the court. Because this evidence bypasses cross-examination, the rules to use it are strict. Rule number 1, the victim must actually die. If the person miraculously survives, their statement immediately loses its special status. It drops out of Section 32 and can only be used as standard corroborative evidence, meaning it has to be backed up by other proof. Rule number 2 is about format. Surprisingly, a dying declaration does not have to be a signed document or even a spoken sentence. This was established in a famous historical case known as Queen Empress versus Abdullah. In this case, the victim's throat had been severely cut, rendering her entirely unable to speak. Yet, she successfully identified her attacker by answering questions using simple hand signs and nods. The courts ruled those gestures were completely admissible. The legal system prioritizes the absolute intent to communicate the truth over the physical method used to deliver it. So, exactly how much legal weight does an unverified, uncross-examined statement hold against a living defendant standing trial? The answer was definitively settled in the landmark case of Kushal Rao versus the state of Bombay. The Supreme Court of India ruled that a dying declaration does not require any outside independent corroboration to secure a conviction. There is only one caveat. The judge must be entirely convinced that the victim's statement was truthful and given voluntarily, without any coaching or pressure. Once those conditions are met, a single, voluntary final breath holds the exact same legal weight as a mountain of physical forensics. To fully grasp the unique nuance of the Indian Evidence Act, we have to compare it directly with English law. In the UK, a victim must have a clear expectation of death. They have to know, without a doubt, that they are about to die for their words to legally count as a dying declaration. Indian law rejects this requirement entirely. Under Section 32, the statement is completely valid even if the victim fully expected to survive their injuries. As long as they explain the circumstances that ultimately caused their death, the statement stands. Indian courts focus strictly on the factual link to the crime, avoiding the impossible task of proving what a dying person actually believed about their own survival. Stepping back, Section 32, Clause 1 reveals something profound about how the law operates in the darkest moments of human experience. It is an intentional design to ensure that destroying a witness does not destroy their truth. By giving a voice to those who can no longer speak, the dying declaration turns the ultimate act of silencing, murder, into the very testimony that convicts the murderer. Thanks for watching.